everyone. Welcome to the webinar series on legal and regulatory frameworks in public-private partnerships. I'm Shyamala Shukla from the Public-Private Partnerships Group of the World Bank based in Washington, D.C. This webinar series is organized jointly by the Open Learning Campus and the Public-Private Partnerships Group of the World Bank. Today, our topic of discussion is Kenya. As you know, we had discussed legal and regulatory frameworks in Kuwait and also Eastern Europe last time with a focus on Kosovo. Today, we will be moving to Africa, Sub-Saharan Africa, and we will be discussing Kenya, a country which has been quite active on the public-private partnerships front in the last couple of years at least, and even before, as it did a number of public-private partnerships in the power sector and other sectors. Our speakers for today are Nathan Rono Tumising, who heads the legal function in the Public-Private Partnerships Unit of Kenya. And we also have with us today Jeffrey John Delman, my colleague from the World Bank Group. He's a senior specialist in the PPP group. He's based in Tanzania. And Jeff actually needs no introduction. He's written a number of books and he's well known in PPP circles. He works all over in a number of countries in Sub-Saharan Africa. He has got experience in East Asia as well. He's worked quite a bit on Indonesia. And before joining the World Bank Group, Jeff worked with Allen & Overy and other firms, legal firms. He has a lot of experience on the legal side as well as financing side. And he works along with all of us, Nathan, Jeff, and I, we all work on Kenya, and we have been looking at transactions as well as fiscal commitments and contingent liabilities management frameworks and project development funding and a host of other things in Kenya. Rono, of course, has been in a leading position and has been working on frameworks, legal and regulatory, in Kenya, and he's also been involved in the work with the counties. He has a very varied background, although he is a lawyer. He also holds a PhD from Warwick University, where he analyzed legal and institutional issues and private equity in Kenya, which is a very, very distinct area of work. And apart from that, he has also been working on institutional frameworks inside Kenya in terms of creating the public-private partnerships unit, where he's worked very hard, and we have a very good functioning, solid unit right now. He's also worked with the ministries to set up their institutional frameworks, and he has been instrumental in drafting the regulations that Kenya has brought out, and now he's very active on the county side. So let us hear from him what he has to say on Kenya, how it's working out, what are the legal and regulatory issues that he has been facing as he puts together this framework for Kenya, and also a little bit on the counties, what are the issues and challenges as you have this whole decentralization story coming up. Nathan, over to you.
Thank you very much, Shamla, for that very elaborate introduction. It's also good to see my friend Jeff in the house. I'm actually quite delighted to be participating in this webinar series this evening, and especially for the opportunity to share my experiences and perspectives on the structure of the Kenyan legal and regulatory framework for public-private partnerships. I will speak for probably about 40 minutes or thereabouts, and then we'll have a question and answer session at the end. The legal and regulatory framework, of course, in Kenya is structured around a development context, and I think the structure of our conversation today will focus on the development context for public-private partnerships in Kenya. We look at the actual structure, the nuts and bolts of the policy framework, the legal framework, and the institutional setup that has been prescribed under the law in Kenya. And then we'll reflect on some of the challenges and emerging realities, as Shamla has very ably articulated at the introductory levels of this conversation. We start, of course, by saying that Kenya does have a law on PPPs, and we'll be looking at the pillars of that legislation. But like in many jurisdictions, public-private partnerships have a context in Kenya. Public infrastructure, as we know, comprises both the social and economic aspects. Wherever you turn in Kenya, like in many developing countries, you see a need. We have poor roads, there's a problem with solid waste management, there's a problem in housing, especially urban housing. There are problems in health, you see challenges in water. So the need is actually quite massive. And so the motivations for expanding scope for partnerships, both in policy and in law, actually goes beyond just the obligation to actually spur economic growth. It also spans the element of moral obligations on the part of government. But as we know, we have a challenge, like many other countries. Our needs usually exceed our means. Our sources of revenue are what they are: taxes, tariffs, transfers, some lending from the private sector. We have bilateral and multilateral aid, but all of this is never quite adequate. The reality in Kenya is that the funding gap is large and seems to be continuing to grow. And that is in tandem with the expansion of the country in terms of the number of people demanding services. Now, we have several options. We can stand up and blame our washing machines for the small shirts that can't fit, or we can blame the large dinner that we had last evening. But the reality is that whichever way we look, the challenge of inadequate resources, a mismatch between the available resources and the size of the need, continues to be a challenge. And so there are a number of ways of looking at these issues. But in addition to the resource constraints, we also have legacy issues. Publicly provisioned infrastructure programs have suffered from a series of challenges. One, there's been poor project selection in many instances. There's also been observed an issue of poor project design. Usually these end up in systems of either cost overruns in project implementation or completion delays. And when we are lucky to complete them, we've got very poor maintenance effects and realities. We've never been quite removed from the challenges of corruption. All of these issues undermine the fundamental idea that basic infrastructure is actually crucial for economic growth and improvement of the quality of lives. And so there's a competition between inefficient systems and the desire for better mechanisms. So public-private partnerships actually are seen in this jurisdiction as offering viable alternatives to the inefficiencies of what has been experienced. Of course, we realize and acknowledge the fact that PPPs can never replace public investment programs, but they provide a very strong value add that in many instances can actually unlock multiply effects across an economy. So the hope that this country has in terms of the structure of the legal and regulatory framework is that by providing these stabilized systems for the procuration of public-private partnerships, the hope is that there'll be realized an expansion in the resource mobilization ability of the public sector to actually address the large shortfalls in terms of public infrastructure. But also because of the discipline that goes with the undertaking of PPPs, the idea is that there'll be a better system for managing fiscal commitments and contingent liabilities that are part and parcel of the PPP ideology. We understand very well that PPPs are not free lunches. They come at a cost. And so this discipline that goes with the undertaking of PPPs that has been built into the legislation and the policy framework are aimed at helping the public sector begin identifying, understanding what the categories of fiscal commitments or contingent liabilities that are linked to projects look like, and there, on that basis, find a mechanism for managing them in a better and more sustainable manner. Public finance, of course, should work for everybody. So the idea under the Constitution is that PPPs, constituting part and parcel of the overall resource kitty of the country, should actually contribute to equitable development and needs to ride on systems that are transparent, competitive, and affording of equality of opportunity when it comes to the procurement dynamic. Because the PPP law in Kenya is not just a procedural piece of legislation, it also is designed to serve as a piece of procurement legislation. And under Article 227 of the Kenyan Constitution of 2010, public procurement is required to be open, it's required to be transparent, it's required to be competitive, it's required to afford equality of opportunity to everybody who wants to participate. And these principles have been threaded into the PPP legislation, as we shall see in a short while. So those really are the rationales that underpin the development context for PPPs. And I think with that background, we can now focus our attention on looking at the actual design of the PPP legislation in Kenya. As we move to that discussion, perhaps it might be of interest to you to note the current structure of the PPP program in Kenya. We have the realization that projects, finance, and the legal framework constitute the three most critical elements that define a successful market for PPPs. Now, the story in Kenya from a legal and regulatory perspective is actually underwritten by very interesting Kenyan experiences, and we shall be reflecting on that as we go along. So far, the Kenyan pipeline has got 71 projects. Now, that's a big project. That's a big program. You will realize that the PPP Act came into force only 3 years ago. And in that time, these have been this has actually metamorphosed fairly rapidly. There's been a very quick ramp up in the level of interest that we are seeing coming out of various contracting authorities, both at the national level and at the subnational level. And at the subnational level is actually characterized by perhaps about 3 clusters of public sector actors, and we'll be speaking to that in a short while. These projects, 71 of them, you can see that a big number of them are in the transport, education, energy, and environment economic sectors. In the transport sector, we see mostly roads, bridges, ports, and airports. In the education sector, there's a very strong bias for currently, of course. We believe that this will change as we go along, but we see a lot of interest in university student hostels. We also see in energy, mostly generation of geothermal power, coal-powered power plants, and an interest in LNG power plants. In the environment sector, we see a lot of interest in integrated water development projects. So mega dams integrated with a bit of hydro, irrigation, a bit of fishing, a bit of horticulture, aquaculture, and things like those. So the dynamism around the structure of the current PPP pipeline is interesting in terms of the scope and reach of the program. I will leave you to look at the actual breakdown of the project typologies in each of those sectors. What I wanted to underscore is the current status. What we are seeing is that a very big chunk of these projects are currently at the feasibility study stage and the concept stage, meaning that the maturation of the pipeline, transitioning from project idea to project actualization, is still on the offtake phase. That says something about the structure of the program. And I'll be making a statement about the quality of the pipeline, the 71 projects, as we seem to see them today, because we do think that the quality of this pipeline could benefit from a bit of tightening to ensure that the projects that remain on the pipeline are projects that actually have stronger viability and deeper interest in terms of what will happen. The reality is that these 71 projects have a rough indicative figure of about $22 billion in terms of the capex investment outlay. Now, that is a big program. When you compare that to the ODA support that Kenya has received since 1963, it says something strong. So there is recognition and I think acknowledgement of the fact that if well implemented, effectively implemented, successfully undertaken, this program for Kenya can be quite transformative. So, what is the structure of this legal framework in Kenya? What we need to remember is that the Kenyan legal framework is very young in terms of history. Until 2009, this country did not have a law on PPPs. But PPPs happened before 2009, especially after 96, when we saw a lot of liberalization of the Kenyan economy. Private sector interests ramped up targeting this economy. But then the projects that happened at that time happened without the clarity that a structured legal framework brings. So we saw projects taking a lot longer to structure. We saw projects taking longer to get approved. There was a bit of confusion in certain instances on who needed to give certain approvals at what stages of a project's development. There were issues around lack of depth in terms of the analytical aspects. The current tests that we have under the PPP legal framework in Kenya did not exist at the time. And so questions of affordability analysis, issues around value for money assessments, issues around careful quantification of risks, and therefore their effective allocation were not always well done. These uncertainties resulted in a number of projects failing, others failing to close at all, lots of renegotiations, and others basically closing but not taking off because certain things touching on developer due diligence were tended to be glossed over. But in 2009, the government adopted regulations under the Public Procurement and Disposals Act. These regulations basically created some institutional framework, a steering committee to oversee the policy and regulatory implementation of PPPs. There was also an issue around the creation of a PPP secretariat to work as a technical arm to the PPP steering committee. A procedure was also established to provide for a mechanism through which projects could be identified, prepared, procured, negotiated, implemented. But about 2 years into the effectiveness of those regulations, it was actually realized that the regulations were not quite sufficient. One, there was no policy on PPPs. Two, the regulatory framework was not deep enough. Three, the institutional framework was not sufficiently robust. So in 2011, the government decided to adopt a policy on PPPs. The policy document recognized the importance of enacting a standalone piece of legislation on PPPs in Kenya. So that was done in 2012. The law was brought into effect in February 2013. Now, this law basically says that if you want to do PPPs in any economic sector, you can only apply the PPP Act. So it has got universal application when it comes to the entering into public-private partnership arrangements. But we have to realize that the PPP Act, while it is the mother legislation on PPPs, actually sits within a wider vortex of legislation in Kenya. First and foremost is the constitutional element. The constitutional element basically states that public-private partnerships as a resource mobilization strategy is actually an exercise in public finance. So the whole chapter on public finance has an impact and an overweening impact on the structure of the public-private partnerships practice in Kenya. The PPP legislation itself is supported by a series of regulations, and I'll be speaking to those in about a moment. Now, the Public Finance Management Act also has a role to play because when it comes to dealing with PPPs, the law says that the Public Finance Management Act says that anything that touches on public finance management issues is subject to the regulatory ambit of the PFM Act. Now, the PFM Act does realize that there are certain exceptions and special mechanisms for conducting procurements, and the PPP law is one of those. The PFM Act, the PPP Act, and the Constitution is therefore linked under the public finance management principles of the Constitution. But very interestingly, for county governments, there is a specific legislation that says that county governments can actually undertake PPPs, subject to certain principles that underpin the conduct of PPPs in county governments. Now, what these pieces of legislation have done are actually to establish a very interesting and unified framework for the conduct of PPPs in Kenya, so that the practice of public-private partnerships in Kenya is today subjected to common legal norms and standards. And they happen within the context of the oversight of specific institutions that are established under the law, and they actually follow certain principles in terms of then the project preparatory element, the assessment dynamics that determine whether a project is a goer or not a goer, and all of these issues. In terms of the regulatory framework, the PPP Act recognizes the need for regulations that provide for a better framework for the implementation of the PPP law. We have an active set of regulations, the general regulations, PPP regulations. They became effective in 2014. These address issues of procedural matters. They amplify the elements of practice touching on general undertaking of PPPs. These regulations have been very interestingly agitated over the last almost 1 year now. They have been heavily relied on. They have been cited extensively in some of the PPP disputes that have gone before the petition committee that have been taken to the High Court. So the regulations are beginning to stand the test of time in terms of how good they are, in terms of how effective they are. What we are seeing is very strong reliance on these regulations by most contracting authorities, and we are very proud that that uptake is actually quite visible. Petitions framework in Kenya is regulated under the PPP Act as well. So whenever there is a PPP dispute touching on the procurement cycle of a PPP process, there is a body that has been established under the PPP Act called the Petitions Committee, and it is given the mandate of actually addressing and resolving any petitions or complaints that may be brought by a private party against a public entity in the context of a PPP. Those petition rules have been led by petition guidelines that were adopted in the year 2014. We now have a draft PPP petition regulations that are currently being considered by the Attorney General, and we expect that these will become operational before the end of the year. We also have draft county PPP regulations, and I'll be talking specifically to this towards the end of this conversation. And these define the framework for the undertaking of PPPs at the subnational level, but specifically within the county government's framework. Another interesting set of regulations under the PPP Act is the regulation that supports the delivery of government support mechanisms for PPPs. And we'll be talking about this in a little better detail as we go further into this conversation. The whole concept basically is that we seem to have in Kenya today a fairly elaborate legal framework, starting from the PPP legislation, the regulatory framework, and we'll now be talking about the institutional setup that this regulatory framework has created for Kenya. So, in a nutshell, what we are saying is that the PPP Act gives meaning, a statutory meaning, to the term PPP, public-private partnership, is defined as a term in Kenya, and therefore there is legal content that is applied directly to this jurisdiction when it comes to PPPs. Now, we know that the nuances of a public-private partnership tends to vary jurisdiction to jurisdiction. In Kenya, we now have specific content. I'll be talking to that in a short while. The law also then establishes that the institutional framework. Now, the institutional framework comprises the regulatory bodies and project-specific bodies. It also comprises the dispute settlements body, which is a petition committee. We'll be talking about the actual institutions in a short while. What the PPP Act also does is to prescribe the whole project cycle in terms of a sequential process. When you want to do a PPP, where do you start? After you've identified your project, what do you do? And after you've prepared your project, what are the next steps? What statutory approvals are supposed to be obtained? By whom? At what stages? All of these issues are defined in the law. The law also creates a framework for the assessment of fiscal commitments and contingent liabilities. And I'll be speaking to this as well in a short while. It also prescribes the specific procurement methods that a PPP process might adopt. And in this regard, there are two possible options that the law creates on how one can undertake a PPP. The tender process is regulated. What types of procurement methodologies can be used in terms of the competitive or non-compete process? What type in the compete process? When do you actually prepare yourself to shortlist or qualify bidders? What sorts of documents do you apply? Which institutions manage that particular stage of a tender process? When you go to full tender, what institution needs to run that process? What documents govern that process? When you want to use exceptional procurement methods like adopting a preliminary bidders process or competitive dialogue, what do you do? So all of these questions are addressed in the legislation. And so we find that these provide very clear mechanisms and enablers to practitioners of PPPs in Kenya. And while it has also been said that this process is a bit complex, it's a bit elaborate, very highly prescriptive. On the positive side, those who have come to understand the process say once you understand it, it is easy to anticipate what a PPP project cycle looks like, and it is easier to prepare yourself to actually implement that PPP program, right? So in addition, of course, there are specific provisions on government support mechanisms. If a project requires to be supported, either to close a viability gap or to ensure that certain demand guarantees are made available for a project, under what conditions are those provided? If a project requires a government support letter or some other comfort from the government in order for a project to close financially, what are the procedures to be followed? The law takes these a little further by then creating a framework, a financial framework for the addressing of these issues. So it creates a project facilitation fund, identifies the sources of these funds, how can this fund be resourced, and then also creates a framework on how these funds can be applied. And there are specific issues that we'll be discussing in that regard. So essentially, those are the highlights of this legal framework. Now, very quickly, PPPs are understood in Kenya, like I said earlier, in a legislated context to mean arrangements, contractual arrangements between a public and a private partner. And the most critical element in this definition is that that arrangement must be for the performance of a public function. Now, here is the most interesting element. The public function must also be already identified within a planned investment framework of a public institution. This means basically that you, as a contracting authority, as a public agency, would not be at liberty to implement a project and you call it a PPP if you had not already pre-identified it in your investment framework. Now, this deals effectively with episodic projects or pet projects that could be wasteful of public resources and do not address the infrastructure development priorities of the government. All right. But because they are contractual arrangements, then we know that they actually create principles of reliance and contractual expectancy. They also give rise to hard claims in terms of fiscal commitments or contingent liabilities. And these issues become very important to keep in mind. The process itself, like I said, is legislated. So before you go to step one on the screen before you, there's a whole range of preparatory activities that need to take place within a contracting authority. Like we said, a PPP should be included in a planned investment framework. How do you include a project in your planned investment framework? For national government entities and even for counties, the whole idea is basically to ensure that your project is either identified under a sector diagnostic study or a sector PPP strategy or some other development agenda that identifies projects of priority and projects that add value to national economic development. Now, once you have identified that as a contracting authority, the law requires that projects that you need to develop as PPPs need to be supported by a very clear, elaborate, and detailed project proposal. As a matter of fact, it was recently decided by the PPP committee, which is a policy organ mandated under the law to grant all statutory approvals for PPPs in Kenya, that PPP project proposals should actually be of pre-feasibility standard, so that the critical questions about project need, project preliminary viability, issues around the institutional structure, institutional readiness to undertake the project, the likely revenue sources of a project, and all of these issues become clear at the beginning. Because undertaking PPPs and preparing a project as a PPP takes money, and it's not cheap. So the whole idea is essentially to discipline the manner in which projects enter into the PPP pipeline space. That process, as you see on your screen, progresses from project proposal preparation and approval to feasibility study stage. At the feasibility study stage, a PPP feasibility study is also regulated in Kenya. It's required to address the technical requirements of a project, the legal requirements, the social, environmental, and economic impacts of a project, and also address the financial principles of a project. Is it affordable? Does it deliver value for money? What is the public sector comparator like? All of these issues need to dovetail to a resolution of the questions whether the project is affordable, whether it gives the public value for money, whether it gives the contracting authority value for money, the end user, and it allows contracting authorities to still continue implementing their project, the principles of affordability. Now, if projects are considered to be viable and to be good to go, then the whole process of procurement, going to market, competitive tender, shortlisting bidders, qualification of bidders, preparation of project proposals, managing and implementing the actual tender, evaluating, ranking of bidders, negotiating the project, the bids or offers that you get from the first ranked bidder, all the way to commercial closure, execution of a PPP project agreement. All that entire process is actually regulated. And so what the law does in Kenya is basically to make the process predictable and to make the process easily understandable. Now, one of the things you will notice on that chart is essentially a series of stars. Every star that you see is a gatekeeping requirement. It's an approval system that is needed for purposes of ensuring that every requirement that is legislated has been met and the PPP committee has signed it off. So if you look at the next screen, we'll go back to the other screen in a moment. If you look at the next screen, you'll see that in step 1, you must get an approval for a PPP project proposal before you can open feasibility study work. And at feasibility study stage, you cannot go to tender before you obtain a PPP committee approval. Now, at feasibility study stage, we have the first checkpoint for fiscal commitments and contingent liabilities. This is a point when we begin to say, is a project going to be affordable? Does it make sense to the public sector? What fiscal commitments might be required by way of capital grants or other subsidies? Are there contingent liabilities? What are the likely triggers? To what extent are these likely to crystallize? And are these contingent liabilities affordable? Are they sustainable? If the answers are yes, we go to the tender process. At step 4, after the tender process is completed, a PPP committee is supposed to then again review the project and financial risk assessment report after contract negotiations to determine the extent to which the fiscal commitment and contingent liability profile of a project, the financial structure of the project, as well as the negotiated technical and commercial terms of a project have shifted, if at all, from the stage and the character that the project had at feasibility study stage. So these gatekeeping parameters become absolutely crucial. And before PPP contracts are executed in Kenya, the law requires that the cabinet signs them off. Now, here is an interesting element for step 5. If a project involves the exploitation of natural resources, the law requires that this must be ratified by Parliament before it can be executed. So for natural resource exploitation PPPs in Kenya, there's a parliamentary process. We are yet to have a project of that nature in this jurisdiction. So going back to the circle, I just wanted to say a couple of more things, then we move on. At step number 8, once a project has been closed commercially and a contract has been executed, the law requires that certain disclosures be made. The law requires that contracting authorities need to tell every Kenyan who the selected private party is, what the nature of the project to be undertaken is, what is its size in net present NPV, in present NPV terms. The law requires also that the disclosures include information whether the project will require the payment of tariffs or end user fees and that kind of thing, essentially to create transparency and accountability around a PPP project implementation. Another important element to note is that the law in Kenya applies Kenyan law to all PPP projects. So the governing law for PPP programs in Kenya and therefore PPP project agreements is Kenyan law. That's an interesting element that is built into this piece of legislation. The law also requires that at stage number 10, once you've achieved financial closure and your projects have moved to implementation, project or contract management frameworks need to be put in place. This is a legislated requirement. Another interesting element about the contract management framework is that another piece of legislation in Kenya, or what we call the Economic Crimes Act, actually makes it a criminal offense punishable by imprisonment to undertake a public project in Kenya without putting into place a project management framework. So there is synergy in the legislative framework. Now, what the black letter staff say and what happens in practice perhaps may not always synchronize. But the reality is that when you look at the structure of the legislative framework, when it comes to project management structures and obligations, there is unity in the law. In the event at stage 11 that projects are renegotiated or supervening events happen and things need to be rewritten in the project agreement, the whole concept is essentially that you cannot alter elements in a project agreement without having them subjected to another assessment of the fiscal commitment and contingent liabilities, and without obtaining approval of the PPP committee to vary project terms. Another provision in the Act basically says, again during the project implementation phase, that in the event projects get into very difficult waters, there needs to be either project takeovers or replacement of project proponents, the Public-Private Partnerships Committee is given the mandate, the right, and the statutory power to actually step in to PPP projects and take over. Now, the mechanism for taking over projects that are in trouble is yet to be properly elaborated, but that provision is built into the law. Now, what we realize in practice, of course, is that procurement professionals frequently make or break a PPP project development process. And in a country where sometimes issues of integrity become a problem, these can become major challenges. But we also have challenges around what we call political input. In Kenya, we understand that politicians don't interfere. They can only add value by inputting. The input can be too much or too little. But the whole idea is that sometimes this element called political input can become a bit overweening, and that can become a problem. So moving on, the institutional framework essentially is two-tier. We have got the regulatory bodies and the project level institutions. The permanent body is the PPP node. The PPP node oversees the overall implementation of the project within contracting authority. But then we have project appraisal teams that are temporal institutions to prepare projects, oversee the feasibility study element, and perhaps convert themselves into the pre-qualification committee to actually qualify shortlist bidders who can then be invited to submit full proposals. But full proposals are evaluated by a different body called the project evaluation team. And once the tender evaluations are complete and projects need to be negotiated, a negotiation committee is put in place. In terms of the regulatory institutions, the PPP unit is created by law as a technical arm to the PPP committee, but also as a center of expertise. The unit where I work is a resource center, providing capacity, technical assistance, guidance, and support to contracting authorities when they are implementing their PPP projects. The PPP committee is a body that is given the statutory mandate to grant all the approvals that are required in that chart that we saw a few minutes ago. The petition committee is given power as a dispute settlements body to actually receive and determine complaints against the administrative decisions of the PPP unit, the decisions of the PPP committee, as well as the decisions of contracting authorities in a PPP tender process, which means essentially that the PPP tender procurement or procurement process and all decisions surrounding them are justiciable in Kenya. They are subject to judicial review. And people who are unhappy with the decisions of the petition committee can actually move to the High Court to have those decisions either varied, quashed, or reversed. And so the rule of law within this context is actually quite robust. And we have seen in the 4 petitions that we have received this year, and the 1 petition that we received last year in the petitions committee, that there is a strong uptake of these institutions by the marketplace. And this gives us confidence that the institutions that have been created are beginning to earn the trust of the market. And so the prevalence or sometimes the arising of disputes is actually not necessarily an indictment of the PPP space, but it's actually a vindication that the institutions that have been put in place can be trusted to resolve any disputes. That strengthens the legal framework for PPPs in Kenya. The cabinet approves PPP project lists, and all the 71 projects that we saw earlier were approved by cabinet, and parliament and cabinet also sign off on negotiated deals at the end of a PPP process. There might be issues around that. But I think essentially what we are saying is that this is a very structured process, and this process helps in the more effective undertaking of a project. We are also taking on board now quite a bit transaction advisory work, and the transaction advisor's footprint in a PPP project circle is quite expansive. And we realize in Kenya that most contracting authorities actually struggle with, effective implementation of projects. And transaction advisors come as a complete suite of experts, technical, legal, financial primarily. And we have seen a lot of value in the about 14 transactions that are currently at transaction advisory stage. In terms of procurement, there are two main methods: competitive procurement method and the unsolicited process. There is only one project so far that has been admitted under the unsolicited framework. It is a fairly difficult process to satisfy, and therefore the bulk of the program is being progressed under the competitive tender processes. There are two optional methods of procurement that can be built into the solicited or competitive tender process. This is a preliminary bidders meeting when we are dealing with fairly complex projects and we need to get a feel from the market on how projects need to be structured. And when we get that feedback, we can then structure or restructure tender documentation and issue them. So this happens after shortlisting, but before invitations to full tender. In the competitive dialogue process, this is for those projects that are particularly complex. In Kenya, this mechanism has not yet been activated. And we consider this to be quite an exceptional mechanism. The challenge with privately initiated investment proposals in Kenya is that we do not have under the law a mechanism for challenging unsolicited proposals. And so frequently it's difficult to actually confirm the value for money in a particular proposition. The law does not overtly demand that the project must be subjected to feasibility study assessment. And so it's difficult sometimes to actually determine whether you are getting a deal on innovation and creativity, or whether you are shortchanging the public by accepting an unsolicited proposal. So these issues become a bit of a problem. But regardless of the methodology that is applied, the law requires in Kenya that every PPP must satisfy the tests of value for money, affordability, and effectiveness in risk allocation. All of these are defined terms under the PPP framework. Essentially, the whole objective is to ensure that at the end of the day, projects are undertaken where they provide clear and strategic operational benefits to the contracting authority, and projects are awarded on the basis of economic advantage. So all of these issues tend to tie in to the end user at the end of the day and to the public interest, which is the fundamental principle that governs and ties these things together. There's a whole range of other commonly applicable standards. There's an obligation for every successful private sector partner that is selected in a competitive tender process to actually ensure that they form a project company. The project company is subjected to a series of limitations when it comes to the shareholding structures. Shareholding cannot change. Shareholding structures cannot change without the approval of the committee, but they can under exceptional circumstances. We've spoken about the minimum disclosure requirements. Every PPP project agreement is required to build in the minimum content that is legislated. Under the third schedule to the Act, there's a provision of about 25 clauses that must be in every PPP agreement in Kenya. These are the makings of preliminary standardization of PPP project agreements in Kenya. It applies a uniform legislation, which is Kenyan law. We've spoken about the principle of natural resources. Any variations, we've mentioned that principle. So all of these issues, including financial reporting and audit requirements, apply to every PPP project across the board. In terms of the support measures that are available under the law to Kenyan PPPs, the law says that we can, as a government, provide either demand guarantees or things to do with letters of comfort or government undertakings to make projects more viable. But it also requires that before this can be done, the FCCL assessments are done and approvals obtained. And to help us achieve that, and with the support of Shamala and her team at the World Bank, we have now established a fiscal commitment and contingent liability unit within the Public and Debt Management Office, the National Treasury. And this unit is now very active in trying to implement the FCCL management framework, which was recently adopted by the PPP committee. The Project Facilitation Fund creates 4 windows for supporting projects. There is a window for funding project preparation activities, including the cost of transaction advisors. There's a funding window to address the question of viability gap funding. There's a funding window to deal with provision of sources of liquidity for contingent liabilities. And there is also a window to deal with the technical mandate of the PPP unit. We have currently 11 sector advisors that we've retained under the Infrastructure Finance and Public-Private Partnerships program that is supported by the World Bank. We have transaction advisors that are working on projects. We have individual consultants working on other elements of the PPP framework. And all of these elements require substantial sums of money. So the unit does have a strong technical assistance mandate that is qualified under the Project Facilitation Fund as a worthy cause for support under this fund. The institutional structure within the Project Facilitation Fund is provided for in the draft PFF regulations. And the sources of these funds, of funds for the PFF, are laid out in the Act itself: grants and donations, tariffs, any success fee that may be payable by a project company, appropriations in aid, or monies from any other source. And we are excited with that last clause, because that last clause in the PFF regulations actually allows for even the creation of a lending window. And in fact, in the Project Facilitation Fund regulations, we have created a lending window to enable the fund to actually adopt and achieve flexibility and dynamism in the manner in which it is able to respond to the needs of the program. But to support these non-regulatory tools, the FCCL management framework, we also have the the PPP manual, which is a tool that we are using to help contracting authorities actually implement their programs. It's a how-to facility. And we started working on the PPP manual at the beginning of this year. We now have a fairly good draft. We have validated it through both internal and external stakeholders. The PPP committee looked at it the other day. They adopted it. We are now cleaning it up for publication. So these frameworks basically achieve a very interesting outcome. And the way I see it, the PPP element in Kenya seems to be characterized under our law as a public function and therefore governance issue. And because of the contractual nature, PPPs are deemed under our laws as contractual problems. And they are also financial assets. The entire program is that resource mobilization dynamic, which basically means that PPPs are an issue in public policy. Lastly, of course, because of the procurement dynamics, it's both a legal and a policy question. We have very interesting observations about what we seem to be seeing in Kenya. The PPP ideology is still very novel, it's new, and there is a bit of a capacity issue amongst contracting authorities. There is also an issue around the element of the absence of sector diagnostic studies. Not every sector has got a sector diagnostic study. Not every sector has got a PPP strategy, but every sector does have some program of development that is usually subjected to the MTEF budgeting process. Now, what it seems to be happening is that contracting authorities are struggling between what they call their planned investment frameworks and what they want to understand as a PPP strategy in terms of identifying that planned investment framework. And I think there's a transition in the thinking from what we seem to be seeing about how people are beginning to approach this space. Some of the work of our sector advisors actually includes the development of sector diagnostic studies and PPP sector strategies. So a big chunk of this problem will be resolved through the work of the 11 sector advisors. The quality of the pipeline, as I mentioned earlier, is a source of concern. And in fact, we are currently in the middle of a pipeline cleanup exercise. We are reviewing each of those project proposals, each of the 71 proposals, to determine the extent to which the contracting authorities are still pursuing them under the PPP framework, to determine the integrity of the project's propositions in terms of their likely revenue generating models and things like those, because the mechanism on which these projects entered the pipeline earlier were not as rigorous as they are today. The whole idea of devolution is a very interesting one. I'll speak to that in the next 1 minute. Project facilitation issues around the unsolicited proposals, the accounting principles for PPPs, issues around local transaction advisory teams. All of these are very challenging elements. But at the subnational level, and I can say, Shamala, we are running out of time. If we can do about 1 more or so minutes, just to reflect on this last element, I think it would be useful. The devolution agenda in Kenya, with the constitution that we now implement in Kenya, we've got 2 levels of government. We've got the national government, we've got the county governments, and county governments are 47 in number. These are governments that depend mainly for their financial mainstay on transfers from the national government. The budgets are very limited, the revenue bases are very limited, but at the subnational level, it's not just counties in this PPP space that we seem to be seeing a challenge in. We see regional development authorities, and there are several of those. We see state-owned enterprises, and we see county corporations all wanting to do PPPs. The challenge is that while we have clarified the framework for PPPs in county governments in the draft regulations that we are about to gazette, and we create institutions, we delineate the jurisdictions, and on the right-hand side of your screen, you can see the county PPP institutions, the county government PPP institution, the county government committee, the project specific bodies. These regulations for county governments clarify that space. But the challenge is that this ethic of doing PPPs at the subnational level is not yet very strong. One, the pipeline that we saw earlier is heavily national government focused. The PPP process is very onerous. County governments that face resource challenges find this to be a little too demanding. Counties face challenges that undermine the effectiveness of how they quickly implement their programs. One is that most of them are very opaque in terms of the institutional levels as well as on the project level. The amount of information available at the counties is a real problem, and this impairs project quality. Issues around revenue basis for projects also undermine the attractiveness of projects. The capacity to contract debt is limited by public law in Kenya. So counties cannot contract debt beyond a certain threshold of the entire revenue base. And this is a very narrow threshold. And this makes it sometimes very difficult for counties to actually undertake projects of a certain sizable threshold. Decision-making capacity is fickle. You walk into counties today in Kenya, you discuss issues, you walk away, the next time you're meeting different people. So even investors are facing a bit of a challenge there. And then there is this knack of every private sector wanting to see the hand of the sovereign in this entire business. So they say, okay, we deal with the county governments, but will we get a small document from the national government saying that we recognize that you are doing business with the county governments? All of these issues are realities that we face. Does anything need to change? We think so, yes, but we don't think the change is a policy, institutional, or regulatory one. What we think is required is capacity building. What we think is required is institutional strengthening. What we think is required is basically addressing the capacity of counties to support and implement their programs. And we have a program that seems to be helping us address some of these challenges. We have a specific advisory mandate on county government support. And this work has actually begun yielding fruit. So I think in a nutshell, what we are saying is that this space has got a lot of, in terms of the structure of the law, a lot of clarity, well elaborated framework. The institutions are strong, they are gaining ground. Recognition and clout of these institutions is gaining ground every day. The PPP disputes process are adding credibility to all of these issues. The subnational programs simply need to be built in terms of awareness creation and capacity building. And so in a nutshell, I think that is pretty much what we could say at this point. And I want to thank you very much for your attention. Over to you, Sham.
Thank you, Rono. Thank you very much. Now we will go over to our expert here. He's been working in Sub-Saharan Africa for a long time. Jeff, for your expert remarks.
My expert remarks.
Yes.
Excellent. Thank you, and thank you, Dr. Rono. Everyone will have noticed the broad shoulders that Dr. Rono has, as he's been carrying this whole thing through over the last few years. It's been an amazing process watching the Kenyan team. They've done such a good job carrying a really, really difficult process through. Let me just raise a couple of questions, a couple of issues, and we see these similar characteristics across Africa and frankly across the globe when we look at PPP. First question is, do we really need this PPP legal regime? Isn't that a bit too much work? Isn't this making life more difficult? And actually it doesn't. It's counterintuitive. But when you layer these rules, when you ensure that government is seeking the most efficient use of capital, when you're ensuring that we're only looking at the best and most sensible projects, when you're ensuring that the rules of the game are followed and that they're understood, that makes it easier for contracting authorities. Because don't forget, the contracting authorities have to be convinced that this is a good idea. We need to help them understand that this is the right way to go. We need to change the way they think about procurement of projects, about infrastructure services, about social services. That's hard to do. It's hard for a contracting authority to trust in this new regime. For them to trust, you need to have a very clear understanding of what that regime is, and a consistency and a transparency in the way that you apply it. And for investors, if you want a couple of individual investments, great. Maybe you don't need much in the way of work on the legal framework. But if you want a program of PPP, Kenya's got 71 projects, and these are big projects coming up the pipe. If you want investors to come in and get serious about your country, get serious about investing in PPP, then help them understand what the rules are. The good investors want to know what the rules are. The good investors are not afraid of competing. The good investors are not afraid of following a process because they know that if they follow that process, their project has been proven. When the next government comes in, that government's not going to overturn everything. They're not going to take all the projects away because there was something odd about that last government, the way they did things. Now this is a fundamental part of the way the country addresses infrastructure and social services. A fundamental way of the way they address the relationship between public and private. And so it looks like it's a real hassle. It looks like a painful process. And to a certain extent it is. It's meant to be. It's meant to be that fire that burns away the chaff, so that only the real grain that purifies the gold so that the projects that you get at the other end are really good. Second, and obviously, the legal framework needs to be flexible. We have this tendency of wanting to come in with a set of rules that are going to last forever, put everything in the law, then Parliament signs it off, and now we know what we're doing. Actually, there's constant change. We're always learning. And so you need that flexibility. So set up the basic concepts, and as they've done really well in Kenya, set up the basic concepts of the law, and then in the regulations, deal with the more detailed issues. And that way we can be much more flexible. We can change the regulations as we learn about the way PPP works in that country. For every country, it's going to be different. And we can deal with specific issues. The municipal PPP at the county PPP in Kenya, fantastic, really interesting area, but it's smaller projects. It's a more difficult counterparty because they don't have the same credit position as the central government. There are a lot of different things that are more difficult, much more local currency finance orientated, much more local investor orientated. All of those challenges require a different set of regulations, but possibly. Sometimes sectors require different regulations so that that sector can own their brand of PPP, so that it can be more linked with that sector's institutions. Fantastic. We do that with the regulation so that it's flexible, so that we can adjust, so that we can respond as the market changes, as investors change, also as contracting authorities' requirements change. And finally, and something that Dr. Rona started with first, and that I couldn't agree with more, the legal framework is not enough. And again, we have a tendency of coming in with this great legal framework that was used in another country, let's plop it in, and all of a sudden PPP is going to work. Actually, no, it's a complex series of interventions. So the legal framework is essential. That legal framework is going to set out the institutional relationships that drive projects. It's going to set out some of the financial framework that's going to drive investment. But it comes down to this combination of projects, finance, and the legal framework. And to that, I would add, and which sort of covers everything, relationships. It's capacity building with the individuals to help them understand what they're talking about, to get them comfortable with this whole PPP world, to get them comfortable with the legal framework and how it works, and to feed back to that legal framework so that it adjusts. Relationships between different sectors and central government, between counties and central government, and a lot of those relationships can be very strained. It can be very difficult for the counties, for the municipals, to trust central government, because the whole idea is that they've disconnected, that there is an independence within the counties. Should the counties trust central government? So there's a massive amount of work to do to create those relationships, and so that the legal framework becomes not just a set of rules, but it becomes a way that we all work together and that we relate with each other. So those are just a few comments, and again, thank you, Dr. Brown. That's really, really interesting. We sort of squeezed down the commentary time because the stuff that's going on in Kenya is so interesting, but really appreciate your presentation.
Thank you so much, Jeff. We don't have much time for question and answers, but we'll take 2 questions so that our participants have been asking a lot of interesting questions. One question is from Mia. She says, apparently the whole PPP process is within the public environment. Is there no need for a joint public-private committee or a body overseeing the process? So, Dr. Rona, could you just touch upon the private sector participation at any level in your whole PPP process? How do you bring the private players in, or do you bring the private players in at any point?
Yes. Thank you, Shamala. The Public-Private Partnerships Committee is actually not just 100% public sector. It has got 4 private sector members drawn from private sector umbrella organizations, apex bodies, the Institute of Certified Public Accountants in Kenya, and the Kenya Private Sector Alliance, the Law Society of Kenya. So on the public sector side, the membership is drawn from principal secretaries. So there is a balance in terms of public and private sector participation in the context of the PPP committee framework. Yes.
Thank you, Rona. And we have another question from Joan, who seems to have just joined. She's asked, what are your comments on the integration of the PPP law within the existing legal framework in Kenya? Is there need for further legislative amendments to allow greater effectiveness of the law? You talk a little bit. You have just 1 minute to answer this.
Yes, very quickly. Thank you, Shamala. Yes, there is need for further integration. What we are seeing in some of the transactions, and I'll speak specifically to a number of elements. One of the projects, or a series of projects in the road sector, for instance, have identified at the project preparatory stage, the feasibility study stages, that there is need for amendments of some of the sector legislations to make private sector participation more effective. So, for instance, the Tolls Act in Kenya, the Kenya Roads Act, require certain legislative amendments to actually allow for full private sector participation, including the collection and levying of tolls by the private sector persons, Issues around axle load controls and overloading enforcement principles are currently the business of the Kenya Police. When you turn over the responsibility of these issues to the private sector, you've got to make sure that the transfer of a risk includes an empowerment to the party that actually holds the risk to actually effectively manage that risk. And so there's recognition that some of these changes need to happen. And quite a number of the transaction advisory mandates require that there is need for identification of what these legislative requirements might look like, what the institutional realignments might look like. We are also pursuing the same agenda through our 11 sector advisors. So incrementally, we are aligning the legislative landscape to become more accommodating of the PPP ideology.
Thank you, Rono. We'll just squeeze in one last question and then we will end this. Shahina has asked, an important part of the framework is the PFM Act, and you had mentioned this. And so her question is, how does it relate to public finance issues at the county level? As you create your county regulations, how do you think it links?
A number of issues. One of them is that is the element of contracting of debt. Public finance management legislation demands and enforces fiscal discipline and sustainability. The FCCL dynamic, for instance, the contingent liability element that occurs at the level of the county governments actually gets recognized as a contingent liability of the national government. And that is why the contingent liability assessments at the county government level is done by the Debt Management Office of the National Treasury. And so that element of what amount of fiscal obligations might be incurred by a county government in the context of the undertaking of a PPP project must be disciplined by the overall dynamic of financial sustainability and fiscal prudence that are principles underpinning the Public Finance Management Act.
Thank you so much, Rono. Now it's time for us to end this webinar. Thank you all for participating in this. Thanks a lot, Rono, for your excellent presentation and your answers to these questions, which have really clarified what Kenya is all about, what the legal framework is all about. Thank you so much, Jeff, for joining us today, and for your excellent comments on how detailed the law should be, what it should say and should not say. Thank you so much. And as we end this webinar, you will see on your screen some questions. It's a survey. Please do answer and help us to make these webinars much more productive from your point of view and from our point of view. Thank you so much, and don't forget to come in for our webinar next week. This will deal with legal and regulatory frameworks and the institutional frameworks as well in Canada, with focus on the province of Alberta. Thank you so much.